Welcome to the Infomullet YouTube channel. If you enjoy this content, please like or share. And if you'd like to support the Infomullet by becoming a mulleteer, visit us on Patreon. We appreciate your support. Welcome. Today is February 10th, Wednesday. It's an unusual time slot for the Infomullet Ask Me Anything because this week we have a special edition focused completely on the Senate trial of the impeachment charge against President Trump. I am Timothy Clancy, your chief mulleteer, and this is Bonky, the emotional support donkey, and a better lawyer than Trump's opening lawyer yesterday. That was quite the opening argument. I don't know if it could be described as an argument for the constitutionality, but anyways, today's special edition is 100% focused on the Senate trial and the impeachment. So the background for this from the Infomullet is if you go out on infomullet.com right now, there are actually 2 Mega Mullet articles. There's 8 key questions that readers were asking me in general. And the first 4 are sort of procedural, and the latter 4 are all about the substance of the thing. We're going to go over all 8 today, but if you want to look for any of these sources, dive down in the weeds, read the analysis. They're both 6,000 words long. They both have 25 plus sources apiece, it seems. There were quite a bit to put out, but check it out right now on the Infomullet. And if you get in an argument with anyone, just share that and tell them, cite that. You'll be golden. I'm not going to brag that maybe I heard that the Infomullet was cited on the Senate floor yesterday. Can't confirm or deny that. It's alleged, but happy to hope that I'm helping out somehow. Let me say some hellos and get started. Charles, Jennifer, Derek, Ishmael, Rory, Mike, and Stephen, welcome. Everyone, and everyone, let's go ahead and get started. So the format today, it's a little freewheeling, as again, this is a special edition, so it's going to be up to you what questions you want to ask. But just to go over what I covered in the Mega Mullets is, and we can follow this loosely here, there were 8 key questions that people were asking, and it kind of lays through. The first 4 are sort of procedural in nature because the Senate trial of an impeachment, we've done this recently. I mean, it was only this time last year, literally this time last year, that we were in the first trial of President Trump's impeachment. So there's actually articles on the Infomullet from that, but this is the first time I'm doing a video on it. So the first 4 is what are the charges and opening arguments, what is the schedule, is the Senate trial constitutional, and what are the key procedures and concepts of the Senate trial. This is all the mechanics of the Senate trial. Why is it being called? How is it going to run out? Is it even constitutional to do this because President Trump, or former President Trump, isn't a president anymore? And how is this trial different than like a criminal trial? Those are mechanics, those are plumbing issues. I wanted to get that out yesterday because yesterday the argument was on the constitution of the trial. Hashtag spoiler alert, it's constitutional. The latter 4 deals with the substance of the charges. Did the president attempt to subvert and obstruct the election? Certifying the election? Was January 6th an insurrection? Remember, you cannot incite an insurrection if it's not actually an insurrection. The first thing I did was establish whether this is or is not an insurrection. Then if it was an insurrection, did the president incite it? And then was the president derelict in his duties? And those are the substance of the charges. So this is the format I'm going to file. As always, throw up your questions if you have. Don't feel free to go down into trivia or down in the weeds. If I don't know something, I'll admit it or make something up that sounds plausible, and we'll see if I can get away with it. So the charges and the opening arguments. So the House in its impeachment charges, just to go ahead and get started, it did kind of a thing where it threw in a bunch of individual charges into one actual charge. So if you look at the House charging document, there's one charge that's like a paragraph long with a bunch of stuff thrown in it. And this is, remember, as I'll get into with the procedures, both the House and the Senate have sole powers to conduct themselves however they want. So legally, this would be dubious because you're throwing in a bunch of different stuff: subversion of the election, incitement of insurrection, dereliction of duty, bad hair. You're throwing all this stuff in, and people may vote to convict on one of those, some of those, maybe not others. You wouldn't be able to do this in a legal trial, but again, Senate trial is not a criminal trial. It's an inherently political act, and we'll get into that. But also in their opening documents, so the 3 main charges: subversion of the election, specifically the certification results, incitement to insurrection, and dereliction of duties. It was interesting to me, as someone observing this, I thought they were going to go with aid and comfort of the insurrectioners, the rioters themselves. That was a pretty clear case, but what they did is they went with dereliction of duties. And I'll get into why this is as we go in the details of it. But if you think about those first 2 charges, they can be subjective and arguable. You're arguing what was said on the call and what was meant on the call, what was said at the rally and how people took it. But when it comes to dereliction of duties, that was a surprising and I think a smart move, because it's very clear that the president has certain duties, and if they can prove that he did not act in those duties, they can say he was derelict in his office as commander-in-chief. Now, the president's defense team, their main argument, they submitted a 78-page document, which was not well put together. It was kind of, if you saw the opening argument yesterday, or at least the opening argument for the constitutional phase, the brief they submitted, the 70, is a lot of the same. It's not very well put together, but essentially they spent most of that brief arguing that the trial itself was unconstitutional, and very little of it defending the president's actions. They basically said he was horrified by what happened. He did everything he could in the White House. But really the important thing is this: the trial is unconstitutional because he's no longer president. Well, bad news for Trump supporters. That argument did not fly by a vote of 56 to 44. Expected split. The Senate decided that water is wet, the earth is round, the pandemic is real, and the Senate has a constitutional duty to try impeachments. Now, in the analysis in the article, I did go through the arguments of constitutionality, and there's a lot of precedents. You'll see this all over, that there's historical precedents for trying people out of office, but I cited my favorite constitutional scholar, and I want to give him a shout out in case he's watching. Bonky does too. His name's Akila Reed Amar, and he has probably some of the best constitutional analysis that's out there. And he went through both a technical analysis and then kind of a conceptual analysis, and the technical analysis nailed it dead to rights. He went to the Constitution and said, the Senate's duty is to try an impeached president. The president was impeached while he was still in office. There is no question that President Trump was still president while he was impeached. That creates the status of being impeached. The status is not contingent upon what the Senate does. The Senate has a duty to try impeachments of presidents, but it is not an act of the trial itself to determine if they are or are not impeached. So the first thing, from a very technical reading, he was impeached while he was in office. That is a factor determined by the House, and the Senate's duty is to try presidents impeached, whether they're in office or not. Now, to a larger concept, I think Reed made some great points that the most important duty of the Senate in these trials, it's not to convict, it's not to bar from office, it's not to do any things. It's to act as a defining the guardrails of what is permissible and impermissible behavior on the president. In that way, it stands in judgment as what are the standards of behavior and sets precedent. Much like a Supreme Court sets precedent for all the laws in the land, Senate trials, the greatest duty of a Senate trial is to set the precedent of what is permissible and impermissible in presidential behavior. And then he goes through the reasons why you might not have an officer who is in office, and he goes through a couple. One is, resigning under the gun. And there is a case of this in the article. The Secretary of War, actually in Grant's administration, was under impeachment. Now, this is a Secretary of War, not a president, but he was under impeachment. He goes in that morning. He sits in the committee, gives an investigation. The next morning, he goes into Grant, hands his resignation. So he's resigned before the House has even impeached him. And that's communicated to the House, and 2 hours later, the House says, screw you, you're still impeached. And the reason why is obviously this case. You don't want people to just resign days, hours, minutes, or seconds before they get impeached by the House. So the House said, no, you're still impeached. It goes to the Senate, and the Senate trial, remember, the Senate has a Supreme Court role here of setting precedents for these kind of impeachments. And the precedent they set is, someone can be resigned, because you know what we also want to do? We want to bar him from holding office. We want to disqualify him. Therefore, it's valid. You may also have, Reed brought up cases where you may have misconduct early in the administration, but the evidence isn't uncovered till much later. You may have a situation where the act is done so late in the game. Imagine a scenario where President Trump does something the day of inauguration to obstruct the inauguration of President Biden. Not unreasonable, valid concern. Would there be no recourse? No. The Constitution sets very clearly, and this gets into kind of where the precepts are, the House has the sole power to impeach. However they want to do it, they can choose to do it. That is a sole power. The Senate, likewise, has the sole power to try. And this is where the division comes, and even though Congress is its own independent body, the division between the House and the Senate are pretty clear. So Trisha asked, this is good. So what are the point of these procedural checks and balances? The lawmakers refuse to apply them in good faith. This is where the Constitution, the ultimate guardrails of the Constitution, you can think of it as layers. And the key is, and Reed actually makes this, he's a constitutional scholar, and he makes the argument that it is perfectly fine for a Republican to believe that Trump is guilty and still acquit him for political reasons. And I go into this in the article in detail because I think it's a fascinating point. By precedent and concept, the Constitution uses elections as the bedrock of all activities in the long term. We elect officials, those officials appoint officers, or judges, those judges make rulings, ratification of amendments, everything is based on the sovereignty of the people acting through the election. And the reason why it's okay for, for example, they're acting in bad faith. Well, take Andrew Jackson. Andrew Jackson, and this is a great example. President Andrew Jackson had engaged in criminal duels before he was elected president. He had killed people in criminal duels before he was elected president, and yet he was still elected president. So the people voted in knowing who they were getting. And Amar's point is that it's okay to acquit, even if someone you think is guilty for the political reasons that your constituents voted in and that's the person they supported. He obviously doesn't hope they do that, but he says it's a valid use of the constitutional power. What isn't valid is to convict for purely political reasons. He says by precedent and historical usage, you should not simply convict someone because it would play well with your constituents. And so he places these elections as the ultimate guardrails. And in fact, at the end of the second article, I sort of remind everyone that if the Senate doesn't do what doesn't perform its duty that we think it should, that falls back on us as the people. We are the ultimate check on every power in the Constitution. And this is why it's also, the Senate trial is inherently political because of this nature, that the senators represent constituents. Those constituents may have voted for someone they knew they were getting, and the senator may choose to vote on that. The trial is inherently political. It is not a criminal trial. The only penalties that can come out of it are political penalties. You're removed from office and you're barred for future office. Now, the good news is between sole power and inherently political, you can use whatever procedures you want. And so the standard of evidence here is not the same as a criminal trial where it's got to be beyond a reasonable doubt. It's got to follow all these things. If let's imagine that the Senate wanted to, or the House impeached a president for something seemingly frivolous and the Senate wanted to try them, they could, because it is inherently political. And even as we get into these things, you can do things that you're not allowed to do in a criminal trial. I mentioned the secret ballot and secret proceedings. The Senate in the Clinton trial, after they heard from each witness, they went back and deliberated in secret to what they were going to do. And you can vote even to change the rules of a trial and make the ballots secret themselves. And that's going to come up later in the trial. Even to the standpoint, there's a presiding officer who's kind of like a judge, but the ultimate power is the Senate. So in Law and Order, in this case, the House impeachment managers act as the prosecutors. They say something, the defense says, I object. The presiding officer, who's the judge, says, I overrule that objection. In Law and Order, that'd be the end of it, right? Unless you're in A Few Good Men, I say something, I object, overruled or sustained. And Few Good Men, you can strenuously object. But in the Senate, the officer of the court, the presiding officer, is not the final word. They can then be overruled by a vote of the Senate. And this is the outcome is not designed to say we're going to guarantee any outcome other than what reflects the constituents' will as the elected senators across 3 cycles over 6 years and represent them across it. Yeah, definitely. I think Rory's saying articles of impeachment would be better served if the country did not have political parties. Remember, the one thing the Constitution did not, there were 2 things many things the Constitution didn't really well address. Let's take a step back. There are many things the Constitution kind of missed, obviously like slavery and, rights of women to vote, stuff like that. But when it comes to constitutional mechanics, two things it didn't well. Judiciary was very new, so it only had a few lines about the role of the judiciary in the Supreme Court, but it really was focused on protecting itself from nobility, foreign involvement. That's why you see so much language in the Constitution about nobility clauses, emoluments clauses, bribery, all these things, because the fear of the new nation was that we were going to have European nobility try and interfere with our politics. It did not foresee the factionalism of parties that has become so rampant, really beginning in the 1830s with the Jackson Democrats, and then eventually the Republicans come in, and they've kind of moved back and forth over time of where they stand ideologically, but those have been the two dominant parties since. And the Constitution doesn't really have checks on political partisanship as much as it does checks upon the branches. Barbara's asking if Green was still in the thick of things, would she have been able to have the Senate decide if Biden could? I don't think that makes sense. So Green is a representative of the House. She could vote on the impeachment after she was sworn in, but she would just be a member of the House. She would not have any say-so on whether, have been able to have the Senate decide if Biden. So let's be clear here. No individual representative or senator can impeach a president. They can say whatever they want. To impeach a president, you have to get a majority vote in the House. To convict him, 2/3 in the Senate. So let's actually use that to the schedule, just to go over the schedule to make sure people are clear on what's going on for the schedule. We've had the opening arguments on the constitutionality. Again, spoiler alert, the trial is constitutional as I predicted. What happens now is there's going to be a couple days of opening arguments, and these are going to last probably through Monday or Tuesday. There was a little bit of a kerfuffle on whether they would take the Sabbath off. Originally, one of Trump's lawyers asked for it, so they wrote into the resolution they'd take off Friday night through Saturday evening and reconvene on Sunday. Now that attorney has said they've made alternate arrangements so they can do it. I don't know if they're going to, but we should probably conclude the opening arguments Monday or Tuesday. I don't know, you can watch it if you want. Because it's inherently political, I am trying to identify the key points. And the next key point is a vote on witnesses. That's going to be Tuesday or Wednesday, February 15th or 16th, after the Senate has heard the, because the way this is done is Schumer and McConnell got together and agreed on a joint resolution. And part of that joint resolution is no other business can be done in the Senate, nor can any changes be made to the current impeachment rules until after they vote on witnesses. So the first key vote is going to be from yesterday. So yesterday's key vote was it's constitutional. You can go forward. The next key vote, will they call witnesses? And all of these votes, all of these procedural votes, it's a 50+1 majority. They've got enough Republicans. This makes a huge dynamic and difference, as I'll explain, from last year's trial where the Republicans had the majority and you were trying to peel off defections. Here you only need one Republican, two if Manchin's playing games, which I don't think he will, to vote a procedural. So the first vote is going to be, will they call witnesses? And there's a whole range of witnesses they may call. I can get into that later. But the votes after that, once you have the vote on witnesses, now the rules of the impeachment open up. And the two things to watch for is if they vote for secret proceedings and they vote for a secret ballot. Now, secret proceedings does not mean the whole thing goes into a black box, you never see it. But what it means is, much like the Clinton impeachment trial, you will hear from witnesses and things like that, but then the Senate will be allowed to deliberate in private, confidentially, after the main things, where they argue amongst themselves and stuff like that. That may or may not pass muster. In this day and age, I can't imagine how they're going to keep it secret and not live streamed on Facebook anyway, so I'm not sure. But the next key thing is the secret ballot. A secret ballot is the concept that the vote to convict can be made secret. And this has a huge implication on whether President Trump will be convicted or not. If this vote does not, if they do not do secret ballots, I don't think Trump gets convicted. I don't think they have the 2/3 majority ready to go. But if they make the ballot secret, then Trump cannot know who voted for him or against him. And you would have a scenario where Republicans, because remember, Senator McConnell's already saying vote your conscience. He may vote to convict. And he's not whipping them to vote for Trump in the conviction. If they do a secret ballot, a Republican could stand up there and say, yeah, I voted for Trump, and then secretly vote against him. And this has very recent precedents. When Representative Liz Cheney was in the House, they had a House conference meeting where they voted whether she was going to be ousted from her leadership position. That vote was made secret. And despite everyone panning Cheney and everyone knocking her for the cameras, with, oh, she's against Trump, She won that vote by 70%. That's a 2/3, that's in excess of a 2/3 majority. So there is, at least in the House, which is much more partisan or heavy in Trump support than the Senate, a secret vote flipped the dynamic. So I'd keep an eye on those two votes. After you get those votes, that's when you have, if they have witnesses, this entire schedule is up in the air because they're going to have to subpoena, they may have to go courts, there's going to be depositions, there's going to be arguments about executive privilege. But again, the Senate, it's inherently political and the Senate has this whole power. Any witness, even if they depose them, the Senate can determine whether that material is true or not. They can simply, if they get a statement from some Trump supporter, they could vote by 51 to 49 that that material is not true, it's not admitted to trial, and it doesn't get included. So there's a real procedural power here for having the majority if they have witnesses and if they use a secret ballot. If the Democrats don't use those tools, I think they're looking at an acquittal. And that's why from a schedule, what really matters is these next votes, probably Monday or Tuesday. So let me pause here. Okay. Yeah, I don't want to get in too much about the two-party system because that will take us off. There's a whole nother radical moderate screed I get on the two-party system and why it forms and what's good about it or not. But so that gets us through what are the charges and opening arguments, what's the schedule, and is the Senate trial constitutional? Key procedures, I mentioned some of the main ones. Let me just check here to make sure that I haven't missed any. I got closing arguments, witness testimony, key procedures. Sole power inherently political. Can they piss? Secret proceedings, secret ballot. Executive privilege. So this is interesting. Normally, what complicated the original impeachment against President Trump and the whistleblower is he exerted executive privilege for everyone that was being subpoenaed. And that's a valid executive privilege. Now, he did it for everything, which is a little unusual. And those court cases take a long time to adjudicate. But when the Senate subpoenas a witness for a trial of a president in impeachment, the Supreme Court has already ruled executive privilege does not apply. Furthermore, if it did apply, it's a question of who can invoke it. President Trump is no longer the president. Whose authority is it to invoke executive privilege? So the difference between witnesses being called now, like let's say any of the witnesses that were in the White House during the January 6th can speak to Trump's behavior. Any of his staff that were involved in those phone calls to Georgia or any other states with election, even going back to John Bolton, they could call John Bolton as a witness to establish a pattern of evidence with this kind of election interference going back to the whistleblower. President Trump cannot exert executive privilege in a Senate trial of his impeachment for a charge. And that means that you could, there's even, there was a alleged plot that the president was going to the acting attorney general, replace him with someone who is going to file the Supreme Court to overturn the results. You could subpoena those people, even though normally those would be under executive privilege. If it's in a Senate trial, you can. Now the problem is that's going to drag the trial out forever. And you've got COVID-19 stimulus relief. You've got the appointments and nominations for Biden's entire cabinet. There's a lot of stuff the Senate needs to be doing. So it's a decision on whether they want to make this trial, and this is really up to the Democrats. This is going to show, a lot of times we're throwing, and it's fair to throw rocks because of the party of reeks somewhat when it comes to Trump and that, but the Republicans in this case are not the one calling the shots. If the Democrats are serious about this, they're going to take the time to do this right. They're going to call witnesses, they're going to vote for secret ballot, and they're going to vote for secret proceedings. If they don't, then it's just then it is inherently political. And then at that point, it's going to end up with a probably majority voting against Trump, probably 50 to 60, 55 to 60 voting against Trump, but not enough to convict. And let's talk about the procedure. If he is convicted, it does not automatically follow that he is disqualified from future office. That is a separate vote by the Senate, and that only requires a majority. So it's 2/3 to convict, but a subsequent vote to disqualify, and that's only 50+1. So you've got this situation. If you've got a secret ballot approved, and I'm a Republican who doesn't want to deal with Trump, doesn't want to go up against Trump in 2024 for presidential contenders, I may want to vote yes on convict and yes on disqualified. No one's going to know it was me. in specific. They may know it in aggregate. And I mean, this is a self-serving. This is, again, it's perfectly valid. You can, this is not a criminal trial. You can vote Trump out simply because you don't want to run against him in 2024. That's what's meant by inherently political. That knife cuts both ways in this trial. This trial is, I mean, there will be trials that are much more criminal in nature coming forward for Trump. Georgia opened one today on the election, and those will be real trials. The Senate trial is inherently political, and they have the sole power to do that. So let's pause here for questions, check where we're at. Christie's asked a good question, procedural question here. What's your feelings if you think they deliberately gambled to push the impeachment trial to after the inauguration, specifically to remove the chance of executive privileges being exercised? So first of all, the House did not know when the trial would begin when they cut the impeachment articles. And you can see this in the impeachment articles because they refer to the current president. You know, the language they use is current tense. Subsequent to that being approved, Senator McConnell and Senator Schumer negotiated, and there was an agreement to move it after the inauguration. A couple things happened from that, and it's really not clear. Like, you know, maybe someone masterminded a critical thing. Maybe McConnell was secretly going all along to make it seem unconstitutional. That's possible. But by doing that, he also ceded his own position as the leader with a majority to run this trial until the Democrats had a majority. There were 2 Georgia Democrats who weren't even sworn in yet when the House impeachment articles were confirmed. By delaying it, the Democrats took control. They got the majority. Now they can run all these procedures. Likewise, to your point, Christy, executive privilege, with the executive privilege, remember, a Senate trial of impeachment, the Supreme Court under Nixon already confirmed that you cannot exert executive privilege in a trial for impeachment. That you cannot, you can make it secret, you can make it confidential, but you cannot exert executive privilege. So I don't know if that was the specific reasons, but the timing of this is incredibly fascinating because it draws up all of these weird complications I talk about. In the Constitution, it says that when you try a president for impeachment, the Chief Justice will preside. John Roberts isn't sitting in that chair. That's Patrick Leahy, right? So what's going on? Well, if you look at the reasons why, and again, Amar describes this very well. Obviously, the president of the Senate normally is the vice president of the United States, and they're the presiding officer. And if they were the presiding officer in an impeachment of their boss, they would be the one who takes the presidency if the boss gets convicted. So all of a sudden, there's a huge conflict of interest, especially when the Constitution was written. The vice president was not your wing person. It was the opponent that you ran against who got the second most votes after you. So you had these rivals, and it didn't make sense to have the vice president sit in. So they're kind of like, well, who next is, okay, Chief Justice. But I linked to the SCOTUS blog that described Chief Justice Roberts' decision to recuse himself. It's not a sitting president. Therefore, whether he's convicted or not does not change the who gets to go where because it's a former president. And he's like, look, I'm not required to sit on one of these things. I did it already. It's not very comfortable. I don't like it. I don't like the court being brought into it. That doesn't make it invalid constitutionally. Remember, the Senate has sole power. And because it's not a sitting president, Chief Justice doesn't have to. So who is normally the presiding officer in most impeachment trials that are not at the presidential level? Well, that's the president pro tempore, which is the senior senator. And in this case, that's Senator Patrick Leahy. That's why he's sitting in. He's very much of the old guard in the Democrats. He's on the head of the Appropriations Committee. He's considered fairly even and balanced. But it does raise the specter of now your presiding officer is a Democrat aligned with the outcome. And it's a valid point, but it doesn't make the proceedings itself invalid. Question, can Trump fight the second vote to ban from office in the regular courts? Is that the case? I really doubt it, Chris. But here's the fascinating thing. No president has ever been convicted of impeachment, let alone barred from future office. So it's an open question, but technically the courts really tend to defer to what's written plainly in the Constitution. And this is a clear statement in the Constitution that says, having been convicted, if you are then disqualified from office, you cannot hold any office of public trust. So my guess is it would go to the courts, and the courts would be like, yeah, nice try. No, the Constitution prevails. You're barred from office. It just wouldn't make sense for the courts to complete, and the current composition of the court would not do it, where they just completely ignore the plain text reading of the Constitution and something like that. It might make an interesting case though, but I don't think it would go there. I mean, look at all the even Trump appointee in what may be a less politically juiced thing with the elections. All the courts pretty much ruled straight down where you would expect them if they were weighing on the evidence, the merits of the case, and constitutional law. When it came to all these election frauds, they're like, no, we're not going to engage in these shenanigans. We're not going to engage in this. I think you'd see the same reaction if you tried to go to a civil courts after you're banned. But never had an impeached president that was convicted, so who knows? Could be an open question. All right, so let's jump now. That's the procedures, the schedule, some of the technical issues. Feel free to ask more as we go on, but let's jump into the meat and potatoes, which is the actual charges itself. And this is where I think this is now the opening arguments are going to go over this, but this is obviously my point of view. It's not meant to be comprehensive. There's just way too much going on. But what I tried to do in the analysis, and this is in that second impeachment article here, which I'm going to throw up on the chat. There you go. If you just see that, that's where this article now goes into the substance, which is where people I think really want to go, is what's the actual laws. And the first question here that I think is important is we know the trial is inherently political. It's not a legal trial. It's not a criminal trial. I will be referring to criminal laws just as purposes of illustration to say, if this were a criminal trial, this is where he committed a crime, but it's not a criminal trial. That raises a question. What's the standard of judgment that the Senate should be using? Now, we know it's inherently political, and the parties are probably going to vote in a partisan way, but it raises the question, is there a standard? As a radical moderate, I think there's a standard of judgment on these actions that we should hold all presidents accountable to. This isn't a Trump-specific thing. This is how I view every president, and it has to do with their oath of office. The oath of office for the president is unique among all other oaths of office. It's, you know, if you go through the people who have to, first of all, citizens don't have to make oaths unless they're naturalized, but civil servants, military members, enlisted and officers, elected officials, judges, all sorts of public officials have to swear an oath. And everyone has to basically say true faith and allegiance and support and defend the Constitution. Got it. Everyone who swears an oath has to do that. Additionally, civil servants, military officers, and judge have to faithfully discharge the duties of the office. But the president's oath goes even above and beyond that. Their oath specifically says, I will faithfully execute the office of the President of the United States and, keynote, to the best of my ability, preserve, protect, and defend the Constitution. So a couple things there that are key. To the best of my ability and preserve, protect, and defend the Constitution, those are not found in any other oath that I'm aware of, and create an additional obligation. Now, the Supreme Court justices have a similar composition, but let's think about what this means. To the best of my ability. Well, a Supreme Court, you can only try the cases that come in front of you. Your power split with between 9 other people in dark robes. You know, there's all this precedent law you got to follow. You got to, you know, follow the rules, right? The best of the ability of a Supreme Court justice is constrained by the office. Well, a president's best of his ability, this is the executive, the unitary power of the entire executive branch is put in one person, the commander-in-chief, head of foreign affairs, appointing, they get to appoint all the cabinet and judges. They conduct clemency, right? They can exert executive privilege. They have all of these formal powers in one person. They don't have to share it with anyone. And they are on duty. You know, a Supreme Court justice is on duty when they hit the gavel, they sit in session, they're, you know, in those dark robes. That's when they're on duty. The president is on duty 24/7 until from the moment they take that oath to the moment their term ends. And those are just the formal powers. You think about the informal power, the soft power. Look, by official protocol, everyone has to refer to the Mr. or Mrs. President or Sir or Ma'am. You always defer to the president. Even if you find the individual who holds the office contemptuous, you're supposed to show respect to the office of president. You know, at any time, there are 2 million federal employees in the United States who will take an order from the president, add in 14 million or 16 million state and local employees who will probably do the same. And on top of that, about 18 million former veterans who are like, you know, they may not like the president, but in some ways they were trained commander-in-chief. So Oh yeah, by the way, 60 to 75 million voters who all voted for this one person to represent them. That's a tremendous concentration of power. So when the phrase "to the best of my ability" comes up, that means something different than, minimum viable, what we would expect any Joe Blow to do. When we say the president, to the best of their abilities, we expect them to do to the best of their ability, preserve and protect, defend the Constitution. And what does faithfully execute mean? Well, there's a good legal definition of this that's been developed over the years constitutionally. It means not to act beyond lawful authority, not to misuse funds or take unauthorized profits, basically don't take personal gain, and be diligent, careful, good faith, earnest, and impartial in the execution of law. And this standard of judgment that they will faithfully execute across those three things to the best of their ability, those are the standards by which I think President Trump can be judged in these three charges, subversion and obstruction of the election, the incitement of the insurrection, and then dereliction of duty. And we will use this standard as we go through each charge. So I wanted to walk through the standard first, because how do you judge someone if you don't have a standard? Well, that's the standard. And I think it's not a controversial standard. It's the oath of office they took, and is the highest oath in the land with the most powerful person in the land. So let's check to see. Yeah, Charles is saying, I don't think Trump ever did any of those three things. That's where you get into, I think a lot of these are, I tried to create the case to be as self-evident and not subjective as possible. So, but again, I hold all presidents this. I'm not a fan of President Obama, President Bush. I'm not generally a fan of presidents because they have that concentration in power. As a radical moderate, I always hold them to the highest possible standard. And people are like, well, if you do this thing, maybe we'll impeach a lot more presidents. I'm like, come on, bring it. I think more impeachments are better than less. Let's demystify the impeachment process and stop holding it up on this sacred thing that has to happen until Oh, yeah. Sarah is devil's advocate. Maybe he did do it to the best of his ability. We'll get into that. That's why I think, Sarah, great point. I think that's why they put it in for the dereliction of duty, because there are certain things, and I'll get into this as we get into the charges. So hold that thought, Sarah. That's the best of his ability. This gets into that interesting subjective question of what was his intent and what did he know? Dramatic pause. Yeah, so if you haven't yet, support the Infomullet on Patreon, patreon.com/Infomullet. Appreciate all the supporters. Got to do the commercial thing and do the pitch. But let's jump into that first charge and talk to that question. What was to the best of his ability? And here we're talking about subverting and obstructing the certification of the 2020 presidential election. So first of all, what I just described, his duty is to the Constitution. Well, pretty clearly, presidential elections are an explicit function of the Constitution, and the president themselves has all sorts of duties and obligations and powers related to securing elections or supporting states whose job it is to oversee the elections. So clearly this falls in the realm of, this is where his oath applies, is in the presidential election, certifying the results. And I could go over a whole bunch of things, but I want to focus here on the phone call, which is the one that's mentioned in the impeachment pardon, with Georgia Secretary of State Brad Raffensperger. So I'm not going to get into all the laws. There's a whole bunch of laws on the Infomullet that describe it, but I'll just mention there's two state laws. Basically, knowingly and willfully commit election fraud or solicit another person to commit election fraud, deprives, defrauds, or attempts to deprive the residents of the state. There's some federal laws there that are applicable. The key one here is tabulation of ballots that are known by the person to be materially false, fictitious, or fraudulent. That's 52 USC 2511, subsection 2511. And the link to the telephone call is in there. So we can really isolate it down. We don't need to get expansive. We can make a huge case that goes back months, but we can also really isolate this down. And I want to share this screen with you so you can see what I'm seeing here as I look at this. Is a quote directly from the phone transcript. So here's the applicable Georgia laws, right, and federal laws. And here's the statement that I want to focus on. This comes from minute 37 to 39:40. This is when President Trump, with his attorneys, is talking on the phone with Secretary of State Raffensperger and the General Counsel of the Secretary of State, Ryan Jeremy. And this is President Trump's warning. It is more illegal for you than it is for them. He's talking about the Democrats there, because you know, he's talking to Raffensperger, what they did and you're not reporting it. That's a criminal offense. And you can't let that happen. That's a big risk to you and Ryan, your lawyer. And that's a big risk. So look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have because we won the state. And flipping the state is a great testament to our country because, you know, it's a testament that they can admit to a mistake or whatever you want to call it. And if it was a mistake, I don't know, right? Very isolated statement, right? The rest of the call is kind of painful to go through. There's a lot more in it than that. But here's the thing, to Sarah's thing about best of his ability. How do you prove someone knowfully and willfully is engaged in election fraud? Well, you look for details like they're looking for the exact amount of votes that is one more than they need. Like if the president got on that phone call, it would be unorthodox and maybe a little weird, but if the president got on the phone call and said, I want you to investigate all fraud, I want you to make sure that whether the votes cast for me fraudulently or for Biden fraudulently, I don't care, just find any of the fraud, that would be one thing. But what he does is he knows the exact number he needs to win, and he's asking for that exact number. And he even states he doesn't care what they call it. He's like, call it a mistake, call it whatever you want. This is a really good indication of knowingly and willfully having an intent to solicit a criminal act, because this specificity is working against him here. And this tape is filled with this, you know, very specific language where he's clearly not interested in the fair and transparent process. He just wants enough to win. And this gets to the duty of the presidents to faithfully execute. When we talk about to the best of the ability, right? What is to his best of the ability? Well, one of the things in the term of faithfully execute is you cannot go beyond the lawful authority. That's a key constraint. When it comes to the election in Georgia, there is an official process by which these votes are counted, hand counted, audited, and then on request of the Secretary of State, there was a Georgia Bureau of Investigation, criminal investigation into the ballots where they sampled ballots and looked at them. Those processes are the lawful authority. What Trump is asking and what this phone call represents is an unlawful authority. It's an extension beyond law. He's not asking him to do another recount. He's asking him to create new law and new procedures. Later, he says, hey, if we just get a new team to recount it, to get some of our people that want to find the numbers, you know, he's basically going beyond his lawful authority as president to make sure this is impartial, and he's clearly self-dealing for his own benefit. And that phrase, where it's you know, specifically the number he needs to win, buries him in this case. Because even if you wanted to say, look, he's just zealous and persecuting fraud, he wouldn't be asking for just as many votes as it took to win. He says, I don't care where the votes are fraud. I just want it to be right. So fix it so it's right. And that's really where it gets that question. To the best of his ability, it's not, he has the ability to simply ask any of his people, make sure they do the recount, make sure they do the audit, make sure there's an investigation. That's the lawful authority that is well within his ability, but he goes above and beyond that. And so I think there's a really good evidence just in, and this phone call, like most things with Trump, it's out in the day. You know, the words that he says himself are usually what end up indicting him. But if the Senate calls witnesses, I think they should. This is just one state out of many that Rudy Giuliani and Trump's attorneys team were trying to overturn the results in. I would like to know if there were any other calls to any other states that sounded like that, because then you can get into a pattern of behavior that shows this is a clear, get some people in the White House. How did he come up with that number of 11,780, right? How did he know that number? Did it just come off the top of his head, or did he have a piece of paper saying this is what you need to win the election? You know, those witnesses can go a lot more to what is the extent of the best of his ability, what is his intent and knowledge, and I think it can really shed some light on that. But and so that's, and there's, like I said, you get witnesses for other phone calls like that. Maybe there's other tape recordings out there. The White House usually records all conversations. Those recordings can be subpoenaed. They're not national security. And even if they were national security, you cannot use national security privileges to hide a crime. And by the way, the one who controls that classification process now is named President Joe Biden. So even if Trump asserts that that was a classified confidential call, he's out of office. President Biden can say, you know what, that call, declassify it, ship it over to the Senate and let them use it, but only if the Senate calls for witnesses and depositions and subpoenas. So that's why that vote coming up Monday or Tuesday is so critical. I think, there's probably enough in just election fraud alone and solicitation for election fraud to really bury Trump. But as I said in the thing, no one really cares about election fraud because a week and a half later, insurrection, right? It's kind of like election fraud is the boy wonder to the insurrection Batman. It's sort of like, yeah, okay, got it. Robin, you're there. But what we really want to focus on is Batman. So the big charge that's coming out of this is incitement to insurrection and dereliction of duty during an insurrection. And that's where I want to focus on as sort of my last two things here. And again, ask any questions as they come up. Hopefully I'm seeing them all as people are asking them. Go ahead and put them on. If you haven't yet, these articles are on the Infomullet. Go up on the Infomullet now. There's 2 mega mullets. Feel free to share them whenever Facebook discussions come up. This video will be uploaded to YouTube in its entirety on Friday, and it'll be split into segments. And this is a special one coming up next week. We're back on our regular schedule, foreign affairs and COVID-19 update. I'm not trying to overlook that there's a lot of other stuff going on. But let's jump in now to the final 2 big charges, incitement of insurrection and the dereliction of duties. The first was January 6th an insurrection? Now, if you watched me last week, I deconflicted a bunch of terms, and I established that the January 6th consisted of a riot, domestic terrorism, and insurrection, and that it wasn't necessarily a bunch of other things because like a coup or revolution. But let's go through those again. Let's establish it. First of all, riot is one or more act of violence by one or more person in a group of 3. Okay, clearly riot, done. Let's not belabor that point. Domestic terrorism involves acts dangerous to human life that are violation of a criminal law, and they're intended to influence the policy of the government by intimidation or coercion. Pretty good argument there that there was domestic terrorism. Now, key legal point here, and this applies to Trump. Just because there was domestic terrorism within the context of a riot does not mean all rioters are guilty of domestic terrorism. I know Ed Cook had asked us before about the felony murder law. I did some additional research. There's this concept called mutual complicity. If there is one crime and many people participating in it, even if you weren't there for the act of the crime, you may be mutually complicit. And this is where felony murder, if you have a group of people that are robbing a bank, that is one crime to rob the bank, a guard gets shot, you're all in on the conspiracy to rob the bank, you all intended to rob the bank, but maybe you didn't intend that guard to be shot, too bad, still guilty of felony murder, you'll get charged. But a complex event like January 6th consists of hundreds, if not thousands, of individual crimes. And although you could tie together the people who beat the cop to death or attacked other officers, those people on the scene can clearly be mutually complicit. They were tied together. You can't take someone on the other end of the Capitol and say they are mutually complicit in that act. They're still guilty of trespassing, probably guilty of a riot, but they're not guilty of domestic terrorism. And that's key, is that these, and there's a lawfare link on this mutual complicity will probably not apply, which is why I don't think President Trump, if anyone was wondering, I don't think he's guilty of inciting domestic terrorism, because the mutual complicity doesn't extend out from the act. Now that clears the riot and domestic terrorism. The insurrection caused a lot of controversy because the main article for the U.S. law on insurrection and rebellion is pretty vague, and I'll share it here so people can see what I'm looking at for the textual definition, right? The basic law, rebellion and insurrection, comes from 18 U.S.C. subsection 2383. Whoever incites, sets afoot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or give aids or comfort hereto, shall be fined under this title, imprisoned not more than 10 years, or both, and shall be incapable of holding any office of the United States. Pretty clear. However, that doesn't actually define what an insurrection is. It defines what the penalty is, and a broad thing, but there's actually 2 sections that are a little bit hard to find, and it's under the power of the president to call forth the militia under the Insurrection Act, which came up last year during the summer protests, and it's 10 U.S.C. subsection 252 and 253, use of militia and armed forces to enforce federal authority and interference with state and federal law. This actually really establishes a crisp definition of what an insurrection is and isn't, because this gets a lot of people tangled up. So 252 says, remember, it's saying the president has a power to call forth the militia when they consider that unlawful obstructions, combinations, or assemblages, or rebellion against the authority of the United States make it impractical to enforce the laws of the United States, in any state by the ordinary course of judicial proceedings. So this is the first part of a good definition of insurrection. It sets a floor. And I know people have asked, well, how do we know that this other act wasn't an insurrection? If you can handle it with regular law enforcement, it's not an insurrection. If you can handle it with ordinary judicial means, it's not an insurrection. An insurrection or rebellion exceeds the threshold where it is no longer practical to enforce the laws through ordinary means. You have to call out the National Guard. You have to call in reinforcements from other, state highway patrol coming in to help locals. That would be the minimum threshold of which an insurrection could exist. This state where the ordinary laws are no longer enforceable in a practical way. But then further, the president can call out the militia to suppress any insurrection, domestic violence, unlawful combination, or conspiracy if. So now this constrains the president, says there are only these things if it hinders the execution of the laws of the state and of the United States within the state, or opposes or obstructs the execution of the laws. That's subsection 253. So what this means is an insurrection is two things. One, it is a circumstance where you are no longer able to use normal law enforcement or judicial means. You're in an extraordinary circumstance. And specifically, that circumstance is aimed at obstructing or hindering a specific governmental function or law. And I go through a bunch of historical examples that demonstrate these historical cases where that is the case. From Shays' Rebellion, before there was even a constitution, you had farmers rose up, commenced on riots that turned into insurrections when they stormed courthouses and prevented courts from hearing debtor cases that would have stripped farms out and handed it to creditors because the whole Articles of Confederation fiscal mess, right? There is a place and a function. The place was the courthouse, the function was to hear a debt case, and the insurrection was the act to which, beyond normal means, you could control this, to delay or hinder that court hearing to prevent the debt from being passed on. You've got the election riot of 1874, one of many insurrections during the Reconstruction period, which I describe as an insurgency. You're talking about Election Day 1874, the Alabama chapter of the White League attacks polling places where black Republicans and white Republicans are voting by a 2-to-1 margin to put in a Republican Party over the reconstructed South. Well, the White League, it's a white supremacy terrorist organization. They attack these polling places. They kill 7 blacks, injure 70, drive off 1,000 people, right? So, I mean, scale and scope is similar to the January 6th insurrection. By the way, Shays' Rebellion, also similar. A couple thousand people, less than 10 people died, maybe a couple dozen wounded. Insurrections do not have to be these big, long, protracted French revolutions. They can be small, localized. But the key thing with the election riot of 1874, again, it is a place, the election polls. It is a function, the election itself, and the sitting of officers, and it is designed to hinder or obstruct that. In this case, they removed all the Republican officials and sat them with Democratic officials instead. And literally the entire county, every position that was going to be going to a Republican, they undid the results and put in a Democrat through this use of force that was above and beyond the ordinary means to confront with law enforcement. Another historical case, 20th century, 1954, Puerto Rican separatists stormed the Capitol and they kill 5 people. Now, this is very relevant to January 6th because this is the only case that results in Supreme Court rulings that are going to would serve as precedents for any of those folks facing insurrection or seditious conspiracy charges coming out of January 6th. And the first one is it's United States versus LeBron. The ruling first defines the attack on the Capitol in terms very similar to our current laws. It's once a political party had abandoned hope of achieving their goal, Puerto Rican independence, through legitimate political processes, they decided instead to use force to overthrow American authority. Well, think about what happened on January 6th. You have a political movement. I'm not going to say they're all Republicans, QAnon, who knows, but they're a political movement. They are Trump supporters. They've lost hope of securing Trump's reelection through legitimate processes, either through the elections or through the courts, and they shift now to the violent use of preventing by force at a specific place, the Capitol, to prevent a specific function, the certification of the Electoral College. This really classifies now the 1954, they were charged with seditious conspiracy for insurrection. That was, and the Supreme Court found, by the way, that's not an impingement of their free speech. And even if you weren't there during the attack, you could be guilty of seditious conspiracy and incitement for being a participant in something that resulted in this. So this comes up very later when we talk about the incitement. Just because it's important to falsify, when is something not an insurrection? Well, you have a 1983 bombing of the Senate chambers. This was a left-wing radical group that planted some bombs outside the Senate chamber. They're designed to go off at night. They blew a lot of holes in the wall, caused a lot of damage. No one was injured or killed because of the timing. So here, even though you have a place, there is no function that it is interrupting. It is not targeting a function. And more importantly, it's handled by ordinary law enforcement. You don't need to call up the National Guard. Now, that being said, it took a couple years to find these terrorists and charge them. And when they threw the book at them. It was 20 years apiece in the charge for this bombing. A lot of them were already in jail from other bombings. So, I mean, it wasn't exactly that this was breaking new ground for them, but they were very serious charges. And that goes to show that anyone involved in the Capitol Hill riot probably is going to be facing serious charges, even if they didn't plan a bomb. They can face some key time. So that gets into some of the historical cases. A lot of experts have already called this an insurrection. Senator McConnell calls it an insurrection. The Joint Chiefs of Staff call it an insurrection. A U.S. attorney has called it an insurrection and filing charges. There's the fact, the question of whether this is or is not an insurrection is probably well handled at this point between the lawses. Even if you go back to the founding fathers, they described insurrections all the time. This is not it may be unusual to us, but if you were a founding father, you participated in one of the biggest insurrections in U.S. history, the American Revolution, sometimes known as the American Insurrection, right? You lived in a spot and time where there were constant insurrections and rebellions, and you lived in that language. So the term, it's a bit unusual for us, but it's not unusual in American history, and it's very clear to me that the January 6th fits this criteria. It was an extraordinary event that could not be handled through normal law means, obviously, and it was targeting a specific place and function going on in that place. This is the difference between what happened January 6th and, say, the occupation of the Mahler Wildlife Refuge, or the protest outside the federal courthouse in Portland. These are things that can be handled by ordinary means. They are not stopping a specific, certainly not constitutional function, something like at the level of the certifying the Electoral College. Even in Oregon, storming the legislature, they stormed it. They were trespassing. It's not an insurrection. It can be handled by the local police, and it's not interfering with the specific lawful authority or function of the government. And this is why what makes January 6th an insurrection, but not everything an insurrection, is those key criteria. So I haven't seen any questions for a bit, so I'm going to refresh here to make sure I'm not missing any. And pausing there, I'll get a drink of water. Okay, I'm not seeing any questions, so if I've missed your questions, my apologies, but I'm going to keep on going. The second to final is, now that we've established it's an insurrection, did the president incite the insurrection? Well, so let's say January 6th is an insurrection. Did the president incite it? This is really the charge that's before the Senate. And let's put aside for the second that the Senate is inherently political. They're probably going to come down on party lines unless there's a secret ballot. When it comes to incitement, there are three specific ways that incitement is determined in the U.S. There's the general incitement to violence. It's called the Brandenburg test. It is if you think about it, incitement is saying something that causes someone else to do something. So immediately it runs into free speech grounds. And the Brandenburg test is the test that the Supreme Court uses to determine if any speech incites to violence. It has two tests, and it's generally, did you direct to incite imminent lawless action? So if I say, hey, sometime in the future, people should do something illegally, that's going to fail the Brandenburg test. It's not specific. It's not imminent. And then also, what is the likelihood that it's going to produce such actions? This is where the president's going to get in trouble, but let me go through the rest of the laws. But this has to occur before the act itself. You cannot incite an act that has already occurred under the general incitement of violence. But under that definition of riot, there is a specific form of incitement, which is incitement to riot. And to incite a riot is to organize, promote, encourage, participate in, or carry on a riot, including urging or instigation other persons to riot. But it doesn't deem, oral or written advocacy of issues or expression of belief, as long as those advocacy of beliefs or opinions are not themselves advocating acts of violence or asserting the rightness of or the right to commit acts of violence. And this is where Trump is dead to rights smoking gun. And I'll get to that in a bit, but remember that. Incitement to riot has a clause in there that you cannot, even if it's just a belief or an opinion, you cannot advocate an act of violence or assert the rightness of violence or the right to commit violence. The final one is seditious conspiracy. And seditious conspiracy is a very particular form of incitement where the act that's being incited is insurrection, rebellion, treason, or war against the United States. And this is a very particular form of seditious conspiracy. This is what the Puerto Rican nationalists were charged with. If you're dealing with an insurrection and someone has incited it, that's generally seditious conspiracy. And the key thing is with the incitement to riot and the seditious conspiracy, it doesn't have to be an imminent connection. Remember, the Puerto Rican nationalists were spread out all over the country when this conspiracy was going on. The Supreme Court found that, hey, if you were part of this conspiracy to storm the Capitol and kill people, I don't care if you were there the day of or helping them from afar or conspiring with them from afar, you're guilty of seditious conspiracy. And that's an important precedent. We talk about President Trump wasn't at the Capitol, but he was there earlier at the rally. And so let's look at what he did at the rally and during the insurrection itself. First of all, during the rally, there's a lot of analysis on what he said. I would be very cautious of saying, well, he said they to go peacefully. Yeah, Hitler in the 1939 Reichstag speech uses peaceful a lot. That doesn't mean we have to take him at his word. We can use the overall context of the rally, and it's filled with violent imagery to fight. Don't be weak. You're going to lose your country. You better go get these. It specifically calls out Congressperson Representative Cheney, Vice President Pence as weak and needing to go. He talks about good people fighting bad people. He say there are different rules for the people in front of him. And this fits the Brandenburg test of specific, but let's think about the likelihood. This is the President of the United States. He has all this power, and these are his most fervent supporters, right? These are people who paid on their own ticket to get there, went out in the middle of January when it's freaking cold, sat there and held a rally for this guy. There's a high likelihood they're going to do something because of who he is. This is where, when we talk about that faithful execution of the office's duties and the best of the ability, the president has enormous power, and it's not to the best of their ability to just go casually misusing it. There has to be care and consideration in how they use that power, especially when they use violent imagery and violent terms because of the nature of the aura of command they inherently, either by explicit statute or by inherent sort of respect and culture, they get, especially when you're talking to your own political supporters. This, I think, passes the Brandenburg test, and you can see it in the parlor videos. During the speech itself, after Trump's most inflammatory rhetoric, a group of people leave the rally and begin heading to the Capitol. That creates a causal chain of events. And you can argue that it was building up of the previous speakers. I don't think they're off the hook either, but the president himself, he said, I will be there with you. I will march with you. And if you look at the parlor videos, which are linked in there in the catalog, you have people moving from that rally to the Capitol saying things like, we're here for Trump, we're with Trump. They believe they are acting with Trump in this. Now, it's not exactly evidence of guilt that someone says, well, I think I was incited by that guy. You still have to prove incitement, but you have here the rally, the departure from the rally of a group, and later lots of people, leading to the Capitol, which then results in the insurrection. I think that is yeah, Rory makes a great point here. The rhetoric in a political speech is a very slippery slope. Simply the word fight is not enough. And like people say, I got to target these people. I am not a big believer. Like you'll see people get all up in arms with a crosshairs on someone. I don't think that's generally incitement to speech, but it is the causal chain of events that I think categorizes it. If the president had said, I think we need to fight, but nothing happens, then I don't think there's any, it's very hard to make the incitement case. It is the causal chain of events that really provides the context here. And then, and Rory, to your point, what happens next, I think, is even the stronger case. So we're going through time-wise. This is the rally, and I think there's an arguable case that it would pass the Brandenburg test. But remember, what was his behavior during the riot and the insurrection? This is where we really can distinguish, because the president's defense is that he was horrified, he was aghast, he was shocked at the lawlessness. This gets to a behavior. Now, you could call witnesses, and I think those witnesses should be called. What was the president behavior like during it? There's allegations he was watching TV, he was gleeful, he was walking around. If he didn't intend to incite this, then someone can testify he was pale-faced, white, he was shocked, he was explaining to people what can be done. If he's gleeful, that means that's kind of what happens is in the realm of what he wanted to happen. And specifically, we have actual evidence of the president's own state of mind during the insurrection, because during the actual, while they're in the Capitol, while the insurrection is going on, the president is calling Congress people and kind of coordinating more strategy about how to obstruct. But then he sends out a tweet, and I want to put this tweet on. Now, it was later deleted, but nothing in Twitterverse ever gets deleted. During the riot itself, he made several tweets, but the smoking gun one is he says, "These are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots who have been badly unfairly treated for so long. This runs directly afoul of the incitement for riot provision of that you cannot give rightness of or the right to commit an act of violence." This is basically giving cover. This is saying, hey, look, it's right for them to do what they did because they're great patriots. The election was stolen. This right here, I think, Rory, is one of the key ways that I would distinguish from, okay, Brandenburg might be a little slippery. The word fight might be a little controversial. But here, during the riot itself, he is giving the rightness of an act to commit. He's saying it's okay they do this. You should expect this to happen because, look, the election was taken from them. These are great patriots. And his public statements, he calls them very special people. He calls them great patriots. These video statements, these are Trump's state of mind after the Capitol has been breached. This is not in the rally ahead of time now. This shows his state of mind during the crucial events after the violence has already begun. And so if the defense is he was horrified, he was aghast, that doesn't come through in his statements. He tells them to go home in peace, but he's still calling them very special people, great patriots. Now, someone may say this is just Trump's way of talking, that he puts out these superlatives, and that's just, well, guess what? He can be criminally liable for using those superlatives at a very wrong time. And I think this is the case where you can say his incitement wasn't just, because remember, no one was sure how it was going to end at, say, 6 o'clock, 5:30. You still got people in the Capitol. You still got thousands of people in D.C., we know from the benefit of hindsight, it was ended and there were still fisticuffs and some arrests and trespassing and things like that. But it largely was over by about 6:37, whenever it was cleared. But in the middle of a riot, if you come out with a tweet that says, or a statement that gives cover or support as to the rightness to be violent, that's where you get nailed. And I would say that anyone who did that, I don't care whether they're Democrat or Republican, if you do that in the middle of a riot and give violence, like you see an arson building, a building that's been burned from arson, you say, well, that's justified because of X. Yes, that person is guilty of incitement of a riot under the specific clause. And I think they should be prosecuted because we cannot justify violent acts or the rightness of just in the time it happens. There's a difference between later academic discussion about, I mean, I get in this all the time. What are the causes of riots? What happens? There's a place and time for that. But in the middle of the riot itself, that is not something you want to be doing, especially when you have sworn an affirmative oath that has an affirmative duty to protect and preserve the Constitution to the best of your ability. And this gets directly into the last charge. The last charge being, let's see here, I'm making sure. Yep, some people are saying hello, catching up. Okay, so there's a question out here. When do we stop talking about Trump? Okay, that's a very good question by Sarah. We'll get it out there. Rory, I don't agree that it implies all politicians would be responsible for actions taken by constituents after speech. It is too broad an interpretation. I hope I'm not getting delayed, and that's an earlier one. If I say, I think people should fight, and I'm a politician, and my supporter goes out and punches someone, right? Gets in a brawl, and I'm standing there while the fight's going on. If I say, "Hey, stop fighting! Don't do that. That's terrible. Stop. That you have no reason to do that." That then states my position very clearly as being against that incitement. But if I say, yeah, keep doing it, you got, of course you should hit that guy. He took away your vote, you know, go get him. That is where giving the rightness of an action is giving too much cover. And that is where you really get in crosswise. Now, remember, for there to be incitement, something has to happen. It can't, any speech where nothing happens, there's no incitement unless it's really outside the pale. But generally, incitement laws are only added on when an event has already happened. You don't see incitement charges occur when there is no act. There's got to be some criminal violence, and then they go back and say, okay, who's guilty? And honestly, I wouldn't mind if more politicians were responsible for their words, because I think when we have really, really low standards, we sort of argue this race to the bottom standard where we hold no one accountable. Politicians especially take oaths of office. And although I'm talking about President Trump here, as a radical moderate, I hold this for a lot of people, right? When you take an oath of office, that should mean something. And you should be held to a different standard than a private citizen, especially when you are acting in the duty of your office. Now, if obviously there's me on the infomullet saying one thing, and then there's me in a bar with someone, that's a distinction. There's me at work versus me at home. There's if you're a judge, you're on the bench or maybe working. Those are different states. But the president is unique in that they are all, well, maybe some military officers. You are always on duty. And I liken the oath of office the president takes as to being like an oath for a military officer. You're always on duty. You're always under you're under that behavior, and the president has this enormous amount of power, and it says to the best of his abilities. So even if we argue that, hey, other politicians shouldn't be doing this either, that doesn't give a excuse for the president's behavior, because their oath specifically says to the best of their ability. And this gets into the dereliction of duty, which is, I think, the most damning charge, and not one I saw coming. I did not see a dereliction of duty charge, but it makes sense, because if you think about it, let's do a thought experiment. Let's say President Trump isn't at that rally. His proxies are there. Steve Bannon's there. You know, now that he's pardoned or whatever, he's there. Or maybe say President Trump won the election and it's Biden that's out there and it's Democrats he's talking to. President Trump's sitting in the office. He's sitting in the White House. He's not at the rally. There's no question of incitement at this point. But then an attack on the Capitol happens, during which the certification electoral college is interrupted. What are the president's obligations at that point? What are the duties the president has when the Capitol is attacked during a function explicitly stated in the Constitution? Well, we go back to the oath. He has an affirmative duty to the best of his ability to protect, preserve, and defend the Constitution. Pick up the phone, call the National Guard, call the agencies, get something moving. Now, this is what we don't know. We have allegations going around, and we believe that the National Guard was authorized by Vice President Pence, not President Trump. Why is a little bit of a question mark. There's some allegations that President Trump refused. I don't want to get into that until there are witnesses, but the dereliction of duty charge is the most black and white charge of all of these things, even if we say the rest are entirely subjective. For sake of argument, let's agree with the concern they're subjective. It gets too much into free speech. The president has an affirmative duty to protect the Congress while it's conducting constitutional affairs. What did he do to satisfy that duty? Think of it this way. If you were the head of the Secret Service and rioters breached the White House and you failed to authorize lethal procedures, you failed to call for reinforcements, you failed to act, you are derelict of the duty to which you are sworn to do. Whether the president is killed or not, you have been derelict in your duty as a Secret Service officer. The president likewise has a duty in this case. And if they come out with a witness that says he refused the National Guard, or he just sat there and watched TV and didn't take any action, that I think is regardless of who this insurrection might have been, that is a damning dereliction of duty, and I think the most black and white charge. But to get there, they're going to have to call witnesses. I don't think they can make that case without witnesses, because it's a he said, they said, who said, what said, it's all very murky, who called who. We know when National Guards were deployed by governors, we believe that the vice president made that authorization, and it's statutorily, the president has the authority to call it the National Guard, but for very common sense reasons, that authority is delegated to both the chief of staff of the Army and Vice President Pence. You can think about continuity of government. The president gets killed or there's a nuclear attack. You want to have multiple people who can call it the National Guard. So that's fine. That's legal. But why did Vice President Pence do it and not President Trump? And was there any action that the president took from the time the riot started to the time it was over, besides putting out that video, to use the powers of his office to suppress that insurrection. And I think that's going to be the hardest one for the Republicans to swallow, because you could get into it's a political speech, you can get into it's free speech, you could put aside this private citizen, it's just election, whatever. But if the president fails in a duty to secure Congress while it's under attack, that is a pretty black and white. But again, Senate trial inherently political, and as Amar says, it is a constitutional precept that even if you think the person is guilty, you can vote to acquit because your constituents want. And this is why, with all of this analysis and context, the most critical vote, I think, comes down to the secret ballot vote. Oh, I see you two are talking. I'm seeing now in the questions that Mike and Rory are talking to each other. Sorry, when I'm doing this live, I can't see who's replying to who, so they all show up as independent statements. So apologies, Rory, if I misread a reply to Mike as an independent statement. But again, so at the end of the day, I think this ends up, there are 3 charges against the president. I think there's good arguments that with what I've gone that and think about this, go back to what the Senate's duty is, right? The Senate's duty is to set permissible behaviors for a president. What are we saying is permissible? Well, we're saying it's impermissible. The president will not subvert or obstruct certifying the presidential election results. They will not incite an insurrection, and they will not be derelict in their duty in suppressing an insurrection. Pretty clear, pretty permissible, impermissible, well-defined things. The question is the Senate going to do its duty to render a judgment and say these are impermissible activities? Is it going to do part of it, some of it? We won't know. We'll have to watch and see what these votes are and the procedural aspects, and especially whether they go with the secret ballot. Now, after yesterday, those who watched yesterday, President Trump's defense did not help him. I mean, it's a tough defense to begin with because, there's 5 people dead. One of them is a law enforcement. One of them is an Air Force veteran. Some of them are trampled. There was hundreds of federal officers injured, right? This is a real thing that happened. So this is a hard thing to defend to begin with. And then the defense team came out yesterday and just blew it, just a completely randomly incoherent defense, which means the Republicans, even if they want to do it for political purposes, it becomes more and more apparent that they're doing it purely for political purposes, which again is their right. That's the Senate has sole power. And if you are a senator, you can choose to acquit, even though if you think they're guilty because your constituents do, you just can't choose to convict. But if the defense fails to make an adequate defense of President Trump to the level they did yesterday, it's going to be increasingly hard to justify this. There's rumors that Senator McConnell, after yesterday's presentation, once again reiterated, he went out of his way to reiterate that this is going to be a vote of conscience. That is code in the Senate. If it's a party vote, you are expected to vote and you will be whipped. The party whip will come around and make sure you're voting for the party. A vote of conscience is code for do as you will. There will be no repercussions. You won't lose your committee seat. You won't lose your special perks or benefits or any of that stuff. We won't punish you. Vote your conscience. There's still rumors that McConnell himself may vote to convict. Now, I don't want to set false hopes because the reality is at every chance the Republicans have had to, and there have been several of them handed on a gold platter to rebuke or set limits on President Trump's behavior, they've opted not to, or they've only done it on their way out the door as they're resigning. So again, the most likely outcome is a acquittal of President Trump, but there will probably be a majority that votes to convict, probably 55 to 60. And if they vote on secret ballot proceedings next Monday or Tuesday, that's the one to watch. I'll be watching it very carefully. Then you might see a conviction because you might have, remember, in the House, when they went to remove Representative Cheney for voting to impeach Trump and speaking out against him, even though 100% of the people spoke against her, very few supported her. When they went to a secret ballot, she won that vote by 70%. That is in excess of the 2/3 majority, and under the Senate, that would convict 2/3 of the Republicans vote to convict Trump. He'd be dead in the water. So that's where we're at. That's any other questions, leave them on here. I'll try and answer them. This has been a special edition of the Facebook Live Ask Me Anything. Next week, we'll be back as usual with foreign affairs. Again, if you turned in late, there's a lot going on foreign. I'm not trying to ignore them, but there's a coup in Myanmar. There's protest in Russia. There's protest in India. There's protest in Bangladesh. There's COVID-19, we have a variant now that looks like it's reducing the efficacy of the vaccine in South Africa. That variant is spreading. Very serious things. We'll be back next Wednesday to cover those. But today I wanted to focus on the impeachment and the specific articles of impeachment and the analysis, the procedures, and all that. So this video will go up in its entirety on Friday, and over the weekend I'll cut it into segments. I might not get it till next week. There's a lot going on, but please check out the Info Mullet, 2 Mega Mullet articles, and share those if you want. for people to go into all the sources and details that I've talked about today. And if you haven't yet, follow the page, and check us out on Patreon. We appreciate all our military, senior military, and Medici military support. It's what helps me be able to do this thing where I can do breaking news coverage and in-depth coverage like this. All it takes is $5 a month for www.patreon.com/infomullet. And from Bonky and myself, not quite on the Senate floor, not quite a CNN analysis or Fox News analysis, but hopefully you've enjoyed it. And with that, we're going to sign off. So again, it's still dangerous out there. Be safe. Stay at home if you can. If you can't, wear a mask, and be good until next week when we'll do this again. Thanks for watching the video. Hope you enjoyed it. If you'd like to follow the InfoMullet, visit us on Facebook or Twitter. And if you'd like notifications when we post new video content, click on the red subscribe button below the video. If you've ever wanted to become a muleteer and support the InfoMullet, visit us on Patreon. We appreciate the support.